Right, so one of the key elements in putting together a quality shared use agreement, shared use plan for your facility is to have some level of risk management for your facility. Now, most of these facilities that are going to be engaged in shared use probably already have a pretty detailed risk management plan if they have any insurance. In most cases, you're going to have insurance for your facilities. So your insurance company is going to require that you do some level of risk management. I want to touch on some of the key aspects of risk management because I think it's important whether you're an agency that's looking to use someone else's facility or whether you're the host facility, you're the host agency that's going to share your facility. You need to understand, I think, some of the basic principles of risk management and how they might apply in your particular situation. So let's address a few of the key principles here. In all states across the United States, from a liability perspective, if you are sharing your facilities with someone else, you're held to the highest standard of care. So what does that mean? You need to provide a facility, an environment that is reasonably safe. What does reasonably mean? Reasonably is exactly what you and I think reasonably is. If you look at a situation and you look at a facility, let's say it's a baseball field or a basketball court or a playground, what would a reasonable average person expect in that particular environment? Well, you'd expect it to be free from hidden or unusual dangers. You'd expect it to be in reasonably good working order. If there was something that was dangerous that could cause harm to someone, you would expect that to be removed or partitioned off so that it doesn't create an injury. And that's how you should approach this from a risk management perspective. Look at the facilities, the equipment, the environment that you're looking to share or you're looking to acquire for your particular program, and evaluate it from the perspective of what do we need to do that's reasonable and make sure that we're not doing anything that's malicious or is intentionally going to harm someone out there. So what does it mean to be reasonable? Well, there's three elements that really need to exist or are most common when we're talking about being reasonable within the context of liability exposure and risk management. The first one is safe environment. You need to provide a reasonably safe environment for people to engage in whatever activity the facility is intended for. The second part is you need to repair dangerous conditions. Things are going to break. Things are going to happen that create a dangerous situation in these facilities, so fix them. If you know that they're broken, go out and fix them, and if you can't fix them right away, then restrict the activity from that area so that people don't get hurt. And then finally, you need to warn of dangerous conditions. Some of the environments that we're going to be sharing have inherently dangerous conditions associated with them. Make sure that you do a reasonable warning of that so that people know what they're getting into and then can make their own choice as to whether or not they want to expose themselves to that particular danger. So I'm going to present you with a few scenarios now and ask you to indicate whether or not you think the host agency in this case is liable or not. And this will give you some indication of your level of understanding of risk management and liability exposure as it pertains to shared use. So here's the first scenario. Principal Skinner decides to open up Springfield elementary school facilities to the general public during non-school hours. Pretty common thing, right? He's known that a particular swing set has been broken for 2 months, causing kids to fly off when they swing high. Lisa Simpson uses the swings after school and breaks a leg while the swing detaches from the set. Here's the question. Is Springfield School District liable? So going back to the broken swing set at the Springfield School District, you were asked to indicate whether or not the school district was liable for Lisa Simpson breaking her leg. And hopefully all of you got the right answer, and the fact is, yes, they were liable. They had a dangerous situation, they knew it was dangerous, they knew it was broken, and they didn't do anything about it. So they didn't repair a dangerous situation, they didn't warn, and they created something that was hidden or unusual, which subsequently resulted in an injury. So absolutely they are liable and will probably end up paying some fee for Lisa Simpson's broken leg. So here's another scenario for you. Principal Skinner decides to open up Springfield elementary school facilities to the general public during non-school hours. Again, a common shared use arrangement. Marge Simpson is walking around the track when she is struck by lightning. If Marge Simpson sues the school district, will she win? So the answer to the Marge Simpson getting hit by lightning while walking around the track, as I'm sure most of you are already determined, no, the school district is not liable in this situation, and if Marge Simpson actually sued the school district, she would not win. This is something called an act of God. Again, something that couldn't be predicted. Remember we talked about what a reasonable person would do? Well, a reasonable person wouldn't be able to predict when lightning's, well, actually if you're a meteorologist, you could predict if lightning's going to strike. But Marge Simpson would have assumed the risk of walking around a track with an impending storm coming in, and she should have got herself out of the way. It's not reasonable to expect that the school district would run out and warn Marge to get off the track because a lightning storm was coming. Now, if this was a youth baseball team playing in a tournament and you were the school district that was renting out those fields and you knew a storm was coming, that might be a different scenario. But in this case, no, Marge Simpson would not win. From a risk management perspective, there's a land use statute that every state in the United States has that can be quite helpful in certain scenarios of sharing facilities. And that's called the Recreational Land Use Statute. And I've commented on this previously, earlier in the trainings, but I wanted to highlight it here because it has relevancy to a risk management plan for a particular type of facility that might be shared. So if you recall, the Recreational Land Use Statute is designed to promote people sharing their facilities and their land for public use. And the way it works is if I'm a landowner and I decide I'm going to let people use my land for recreational or educational purposes, then if people come onto my land, they assume the stature of someone who is a trespasser. Well, what does that mean? Well, if you're a homeowner and you think about someone that's going to trespass onto your land, do you owe that person any kind of duty to protect them from harm while they're on your facility or on your property? Of course not, right? They're a trespasser. Well, what states have done in a way to encourage landowners to promote the use of their land for recreational purposes, they put this statute in place. So it has implications for a number of settings that qualify to fall under the Recreational Land Use Statute. And in some states, schools can fall under that. And in just about all states, faith-based organizations can use this as a way to share their facilities without fear of someone getting hurt and then filing a lawsuit against them, because they would be considered a private landowner, letting their facilities be used for recreation or educational purposes, so they don't have as high a duty to maintain those facilities. You still want to try to do what's reasonable and keep the place safe, reasonably safe from people getting hurt, but the level of duty is lower, which means your risk exposure or your liability exposure is subsequently lower as well. All right, so I have one more scenario for you, and I want you to remember what the Recreational Land Use Statute is and apply that when trying to answer this scenario. So here it is. Reverend Lovejoy decides to open up the outdoor grounds at the First Church of Springfield for public use and makes an announcement in the county newspaper. There's an old paved walking path on the property that has fallen into disrepair. Bart Simpson is running along the path one day when he trips in a large pothole and breaks his ankle. Is the First Church of Springfield liable? All right, so the answer to the First Church of Springfield liability exposure. If this was a Parks and Recreation Department, a YMCA, a Boys and Girls Club, a school system, the answer would be different. It would be yes, they would be liable for the broken ankle because they knew they had a walking path that was in disrepair and they didn't do anything about it. But because the First Church of Springfield would be considered a private entity, then Bart Simpson becomes equivalent to that of a trespasser. Trespassers, we don't owe them any duty. We can't go out of our way to hurt them, but we don't owe them a duty to warn about hidden or unusual dangers. So in this case, Bart falls into that category. He was walking and using the path under the category of a trespasser. He steps into a pothole, breaks his ankle. There's no liability on behalf of the Church of Springfield.